Minister to reply.
Thank you very much, sir. Let me commence by thanking every member. The debate in post-lunch session in the Parliament is always a bit difficult because many of the members do give their little input and sometimes participate further. But today, the post-lunch debate actually was very invigorating in that every member who spoke very clearly has gone through the amendments, has understood the spirit with which IBC has been brought into this country, with every member's cooperation. And post-2016, with just about nearing 3 years after the implementation, there has been repeated need to bring in the amendments because the amendments were always brought in as a response to what was developing outside of the Parliament, where industries, where creditors, where courts, all of them were using the IBC to give solutions, but there were greater challenges, newer challenges which were coming up. As a result, the amendments are always brought. This time, I'm glad many of the members have credited the government with coming up speedily for what was developing in the recent past, in the last few months, a situation where we thought the legislative intent of the Act itself was being corroded upon, and therefore we had to respond, and we've come out with these amendments. I'm glad very many members recognize that the response of the government has been in time and speedy, and therefore I would just go over rapidly on what these specific amendments aim to achieve, and also then respond to each of the members' questions, also the suggestions. So the Insolvency and Bankruptcy Code, actually the amendment bill which we are talking about now, seeks to amend 7 sections of the Insolvency and the Bankruptcy Code Act of 2016. I shall keep referring to it as the code. And these sections are 26 of 5, 7, 12, 25A, 30, 31, and 33. And they're largely to remove the ambiguities and to facilitate a smooth conduct of the corporate insolvency resolution process for maximizing the outcomes in line with the preamble of the code. I particularly thank Sri Suresh Prabhu, who metaphorically said we have to give a life to these companies. So was the mention by Sri Ashwini Vaishnav, a member from Orissa, who spoke about the speedy, responsive way in which we are coming back with amendments which shall keep the company alive. Also, Jairam Ramesh referred to it. So it's a response to what was developing, and since specifically some of the members have taken the name of the resolution plan and also the interpretation given by the NCLT in the SR case, where I'm glad the points were literally brought out like nuggets, where the interpretation was trying to treat secured creditors to the operational creditors, and treating them at par defeated the purpose and also the spirit of the Act. So with such very serious interpretative problems which were coming up, it was only incumbent on the government to come up with a with such amendments, and amendments actually which are clarificatory in nature. So in order, the intent of the government is to ensure the maximization of value of a corporate debtor as a going concern, while simultaneously adhering to strict timelines. The timelines related point, I could hear many of the speakers did raise questions and doubts if actually we can implement them. Actually, can we have these kind of timelines added? And I'm very grateful to Sri Bhupender Yadav, who very correctly pointed out the spirit behind Insolvency and the Bankruptcy Code. In a changing India, post-1991, we've had quite a lot of opening up, quite a lot of economy and issues related to speeding up the economy, bringing in more lubrication into what we want to do. We're all discussed. And in the spirit of that kind of a change which is happening in India, which has gained greater traction of late, in spite of the global headwinds, we needed to bring in that kind of a reform. And it is not going to be as though it is being done exclusive of the courts, and it is certainly not eroding into the courts' domain. I would just want to bring in this particular quote, or a couple of paraphrasing of the court's words, which will remove from the minds of any one of us who would suspect that by bringing these kind of timeline-related constraints, are we trying to tread onto the court, or are we trying to impose something on the courts? Not at all. We are not imposing on the court is something which I want to explain to you by using the court's own words. In the Swiss ribbons matter in 2019, the Honorable Supreme Court had observed, and I'm not quoting, I'm using their words, so let there not be misunderstanding. I'm using their words, paraphrasing the words of the court. They said, defaulters' paradise is lost through this IBC. So India can no longer be a defaulter's paradise. So because of the IBC, now it's very clear there has to be a resolution. Even if it leads to a liquidation, defaulters will have to be facing law. So that's been recognized by the Supreme Court. Second, again, on the issue of can we amend such laws even as issues are pending in the court? I'm not saying that the court said it in anticipation that we're going to do something, but I'm only using some of these observations by the court. Economic laws need flexibility and experimentation. This is an observation by the court. And if the courts have said that, why are we hesitating in using the legislative mandate that this House has? Legislative mandate is what we're doing. We are not at cross purposes with the court. It is the legislative mandate. And if we don't use our mandate and leave the space open, after all, nothing is left in a vacuum. Something fills it up. But it's our duty to have the legislation, and therefore we are doing it. And again, the court again had observed in the Swiss ribbons matter, we need to move away from traditional approach. Also an observation of the court. So if you are slightly worried, if by saying, and some of our members did observe, are we trying to do something which is very away from what has been the traditional practice? Well, yes, we may have to experiment. And it is because we started the experiment, even in 2016, repeated amendments which are coming, and I would, with one more observation, I would move over to, in fact, quoting the observation of Jairam Rameshji in his participating in a debate earlier, which he himself recalled, in August 2018, which will explain why we have to come back repeatedly with amendments, because it's such a path-breaking code that we've come up with. Supreme Court again had observed the constitutional, and it upheld the constitutional validity of the code. So if the constitutional validity of the court has been upheld, and well within our jurisdiction, well within the division of power as envisaged in the Constitution, the three pillars are using their own areas: legislative, executive, judiciary, the fourth being the media and the press. Within our legislative or the constitutional area of operation, domain of operation, we are bringing in certain amendments. Only the code itself is absolutely constitutionally valid. So let's not have doubts in our mind saying, are we doing too much? Are we treading into the area of the courts? Are we putting restriction on the courts? No, we are allowed to experiment, aren't we? Because the courts themselves have said it. Let me now just sort of, before I get into the details of what I want to highlight, recall, and I quote, I'm glad that the member whose words I'm quoting is himself here. In the August 2018 debate, Jairam Ramesh had said very clearly, we have the Insolvency and Bankruptcy Code, which we are amending from time to time as we gain experience. Exactly. We are gaining experience. And therefore, we are using every opportunity which has to be in time. This time we have been speedy, which I'm glad many of the members have conceded, and I'm very grateful for that. But that's the point. We have to, as we move along, do these amendments. And again, in a different line, Jairam has also said earlier, as I expect, just as he said now too, I quote, I expect that in the months ahead, as we gain more experience in the implementation, we will continue this process of fine-tuning both of the IBC as well as the GST. End quote. So as we gain experience, it's going to be necessary for us to come up with amendments, such amendments which are going to be in response to the developments outside. Now, today's amendments, very quickly, I said there are 7. I would just tell you what is it that we're doing through these amendments. The salient features of these amendments are that we're bringing clarity on allowing comprehensive corporate restructuring schemes such as mergers, demergers, amalgamations, etc., as a part of the resolution plan. Many of you all did mention the resolution plan is something which is going to be determined and framed up by the Committee of Creditors, the COC. Government doesn't give it. Government is not giving the resolution. There is a Committee of Creditors for each of these issues, and they are the ones who decide it. So that's the first thing. We're bringing clarity to include these sort of parts in the resolution plan. Greater emphasis is being given on the need for a time-bound disposal at application stage. I'll, in a minute, give you the details of what kind of waiting list is there before us. It is now our duty. It's our duty as a House which had passed this code to also ensure that we don't clog up. I understand many of the members rightly said, the clogging up is not for anything else but for want of you appointing people. I can give you an answer for that also. I recall Honorable Member Kapil Sibal mentioning that. I have an answer to give for that too. Deadline for completion of the CIRP, which is the Corporate Insolvency Resolution Process, within an overall limit of 330 days, including litigation and other judicial processes. Votes of all financial creditors, which I'm glad very many of you all have picked up, for the scattered, dispersed creditors, some of whom now you can, every day you read, compare them with the home buyers. The home buyers now can have a voice in a separate voting process. They can vote, and their vote will be taken for what it's worth, and therefore they participate in the resolution process. That's being enabled now in the light of so many different issues which have come for the home buyers, which is a very serious issue. Many members even highlighted the quantum of money which is locked up because waiting for resolution. So this will move towards or help towards moving into a resolution situation. So votes of all the financial creditors covered under the section 21(6)(a) shall be cast in accordance with the decisions approved by the highest voting share, more than 50%, that is, of financial creditors on present and voting basis. The basis that we use there is being present and voting. The specific provision that financial creditors who have not voted in favor, this is a very important point, I want the House to take this into cognizance, the specific provision that the financial creditors who have not voted in favor of the resolution plan, do we forget them? No, we don't. Those who have not voted in favor of the resolution plan and the operational creditors shall receive at least the amount that would have been received by them if the amount to be distributed under the resolution plan had been distributed in accordance with section 53. Many members did refer to 53, section 53, and said, invoking section 53, what will be the followed? I'm here very clearly telling you that takes care of not everyone who's voted in favor, but even those who have chosen not to vote in favor, but they will be taken care of under the section 53 of the code. Or the amount that would have been received if the liquidation value of the corporate debtor had been distributed in accordance with section 53. So section 53 takes a full play there as regards those who have not voted. Inclusion of commercial consideration in the manner of distribution proposed in the resolution plan within the powers of the Committee of Creditors. That's another point which Jairam Ramesh brought out as a nugget. When a commercial decision for which the final word rests with the COC was treated not as a commercial decision, it really brought in a very big contention saying, is this going against the IBC's very spirit? And that's why in this amendment, in this speedily brought in amendment to the House, that is a very important point we've brought in. What is commercial shall remain commercial, and that cannot have a different dimension, and therefore that is a very important part of this set of amendments that we're bringing in now. Clarity that the resolution plan, shall be binding on all the stakeholders, including the central government. I'm glad many members, inclusive of Shri Alphonse, said central government shall also be a party to the resolution plan. You're bound by it, and that is something which this amendment brings in. And partly answering Jairam's questions, which I'll come a bit later to, but this, if it is binding on the central government, any state government also will be bound by this, and also local authorities, to whom a debt in respect of the payment of the dues may be owed. Clarity also is being brought in that the committee of creditors may take the decision to liquidate the corporate debtor any time after constitution of the committee of creditors and before preparation of information memorandum. Even then, the moment the committee of creditors is constituted, the motion sets pace. So that has to be very clearly laid before, and these are the changes, these are the amendments which we are bringing in. So the changes are expected to lead to a timely admission of applications. That's the most important point. Admission stage itself, the delays are worrying. So we are expecting to lead to a timely admission of applications and timely completion of the corporate insolvency resolution process. Analysis of data available demonstrates that there are delays in admission of applications and spillage of CARP cases well over the time limits which are permitted through the code. The amendments are expected to again address the issue of sanctity of timelines of completion of the entire corporate insolvency process. So if these are the larger picture with which we are moving ahead, some of the specific issues which many of the members have raised, I'd like to answer them. I'll start off with Sri Kapil Sibalji, who had raised, in fact identified and said, too many amendments are coming through, you're bringing in such amendments which may not be implementable, and so on. He broadly mentioned that 27 amendments have been already brought in. I just want to clarify, 27 is not correct. This is the third amendment to the IBC code. The first bill amended 8 clauses. The second bill amended 38 clauses. And the third one, now we are coming up with amendments to 8 clauses. So as on 30th June, 101 were withdrawn, the cases. 120 were resolved. 475 moved into liquidation. And of the 475, 349 were in the BIFR or were sick units. This point is being mentioned like in passing, but I want to underline that majority of the cases which are now being under the CIFR are a backlog, the legacy which has come from the BIFR stage. So if BIFR cases are also being dealt with now with a certain rapidity, it's because IBC is proving its worth, and what couldn't be achieved through the BIFR is actually being achieved now. And in that, I'd like to just give you some data. I recall some members were talking about behavioral change. Actually, I credit them for having used those expressions. Actually, there is a behavioral change which is happening for the good. And that should actually convince Sri Binay Vishwam that the whole objective is not to kill and finish off. We are actually coming up with resolutions which can help the unit to live its punarjanma, the next janma. So it's actually giving life, and that's where when Suresh Prabhuji's presentation, he said it's actually giving lives to company which are in almost ICU stage. We are not killing them off, we are giving more energy to them, we are infusing life into them. So I would want to link with this behavioral change point of view to one statistics I want to give before you. Details of disposed cases before admission, even before admitting into the restructuring process, the CIPR. Total number of companies or cases. Under Section 7, they were 894. Under Section 9, they were 5,102. Under Section 10, 83. A total of 6,079 cases. All of them get disposed of even before they get admitted into the process of resolution. What does that mean? It means people realize that if this comes into the effect, and it has come into effect, they have to go through this process. They may probably end up with a process of resolution, but in the process they may be out of owning their companies, or the resolution process would have its implication on their credibility, and therefore many of them have chosen to have a disposal mechanism through which they could get out clear. And what in terms of amount of money has this meant? 6,079 cases, all of them which got disposed of before admission. Somebody did mention, do you have a mechanism? What is the mechanism? This code doesn't. The amendment bill that you're bringing in doesn't speak of any mechanism. No, it does. That is why even before it sets rolling, people have come on their own to say, please, this is what we want to do, dispose our cases. That's the indication of an effective mechanism, not just a mechanism. And an effective mechanism of 6,079 cases getting disposed of before admission meant an amount of 2,84,000 crores being redressed, meaning that's the amount which has been used for settling claims. So if that is the kind of impact we are having because of a mechanism which is in play, before the mechanism sets rolling in a particular case, people have come to get their cases disposed of. Just shows how effective this whole process is. If that's the case that's the way in which much before the cases could come into resolution process, I gave you the data. I'll give you the data for those which have come into the process. As of 30/6/2019, 30th June 2019, 2,157 cases were admitted into corporate insolvency resolution process, the CIRP. Out of these cases, 164 cases were closed by appeal, review, or settlement. 112 cases were withdrawn under Section 12A. I think Sri Kapil Sibal had referred to 12A. 112 cases were withdrawn under Section 12A of the Code. Resolution plan was approved in 117 cases, and 474 cases have resulted into liquidation. In the total 117 resolved cases, an amount of 1,24,636 crores. 1,24,636 crores is realized. In some cases, it's realizable, if I can say, because some of them almost at the fag end of the process. But 1,24,636 crores are realizable. And this is possible with having come into the CIRP. What earlier I gave you was before entering into it. Some more data points. As on date, 1,852 applications filed under Section 7 are pending admission beyond statutory period, the length of wait. Are pending admission beyond statutory period of 14 days, admission. And 5 big cases, some of which Sri Kapil Sibal named, SR, Amtech, Auto, Bhushan, Power and Steel, ERA Infra Engineering, and JP Infratech, and so on. Out of the 12 big accounts referred to IBC, these are pending for more than 600 days. Now, if we think that we can wait, we can't impose on the courts, 600 days. When I say courts, I also mean the tribunal. 600 days due to continuous litigation by some or the other party in the matter. So even the process is waiting because one litigation there, one other there, it's never getting started. So the emphasis to emphasize on the intent of the legislature for time-bound resolution of matters, we've proposed to bring in the amendment to Section 7 and 12 of this code. A bit more data, because I think many of us were very keen to know about figures, saying what is this going to end up in. The status of the CIRPF. I've given till now what happens before, what happens just at the entry. Now the CIRPs, the Corporate Insolvency Resolution Process, under the code, as of 30th June, again, 30th June based data, I want to give you. The status of the CIRPS. Admitted number of cases, 2,162. Closed on appeal, which I read out about, 174. Closed by withdrawal under Section 12A, 101. I've given you slightly later data. Closed by resolution, 120. Closed by liquidation, 475. Ongoing, say, CIRP, 1,292. So, now the number of days waiting. The details on the ongoing CIRPs, along with the timelines, I'd like to mention here. Ongoing CIRPs are 1,292, the figure just now I gave you. Over 330 days, 335 cases. Over 270 days, 445 cases. Over 180 days, and less than 270 days, 221 cases. Over 90 days, but less than 180 days, 349 cases. Over 90 days, less than 90 days, 277 cases. The number of days pending includes time, if any, excluded by the tribunals. So that gives you a picture on what is the kind of weight, and therefore why do we want to bring the amendments for this speeding up. Most of the times we're talking about the cases which are pending. Of course, they will talk about what happens to the creditors. They're waiting for eternity. Analysis of the 475, which I repeated twice, of the 475 CIRPs, which have yielded to liquidation. As of 30th June, 475 which have yielded for liquidation, claims of the financial creditors are 3,15,370 crores of rupees. Claims. Claims of the operational creditors, the risk was both of them are being treated equal and so on, but what are the claims? 31,285 crores. So the total claim is about 3,46,655. The liquidation value here is 24,117 crores only. So these are companies which had been in difficulty and under BIFR for years. Look at the change of profile once they're coming in for the liquidation process through the IBC. So that's what is more important to understand, that the IBC doesn't aim to delay or to just allow the asset value to fritter away, but on the contrary gives solutions where the optimization is possible of the assets. So the liquidation value is only 7% of the total admitted claims of these companies. Important because they're coming from the BIFR background. 73.42% of all these cases, I'm not going through that data totally, are BIFR cases or cases of those which are not anymore as going concerns, which means they're dead cases. 73.42 are in this category. There was this question, probably Sri Kapil Sibal raised, about the operational creditors and financial creditors. All financial creditors, he's an eminent lawyer, I'm not reading the book to him, but I still want to explain this point. All financial creditors form only one class, and they cannot be subclassified into secured or unsecured creditors for the purpose of distribution of monies under the resolution plan. That can't be. The NCLAT, the appellate tribunal, held that the distribution of monies under the resolution plan is not a commercial decision to be taken by the COC. Those are the 2 points on which we are coming up with a clear amendment, so that gray area, it's not gray to me, but the gray area which has come up is being addressed.
I didn't talk about operational creditors at all in the course of my submission. But what I'm worried about is the following. You may clarify it. Subsection B of section 30 says, in subsection 4, after the words feasibility and viability, the words brackets and figures quote the manner of distribution proposed, which may take into account the order of priority amongst creditors, as laid down in subsection 1 of section 53, including the priority and value of the security interest of secured creditors, shall be inserted. My worry is that you are making a distinction amongst secured creditors. And that's the gravamen of this amendment. And that's what I'm worried about. I never talked about operational creditors.
Right. I take that. There was this discussion, I'll certainly give you my response to that. There was this discussion also about the haircut. A lot of our members did speak about, oh my God, this is, I remember my university colleague, Shri Jha, talking about, this is not haircut, it's complete mundan. No, that's not true. Haircuts are there, yes, agreed, but they are only haircuts. Financial creditors, on an average, are getting 43% of the claims, but 188% of liquidation value. This is after rescuing the company and bringing about a behavioral change. So, no, I guarantee you, you shouldn't be worried if they're going to be left with nothing to comb. They will have something to comb. What are the steps taken by the government? The clogging up of the case in the NCLT? Are we blaming the courts and the tribunal when we have not empowered them adequately with infrastructure, soft power in terms of number of people, qualified people, resolution professionals? I want to give a picture of what exactly are the kind of things we are doing, some very specific, some general. In view of the increasing number of cases, government has increased the number of benches of NCLT from 10 to 15 during just the last 1 year. Just 1 year, we've increased it from 10 to 15. Number of members has also been increased in a phased manner, and recently 26 new members have joined, bringing in the total number of members to 52. More than one court has been operationalized in the benches, where large number of cases are pending, such as in Mumbai, Delhi, Chennai, and Kolkata. E-governance and e-courts are also being, those projects are also being implemented for faster and speedier disposal. I'd like to tell you some specific steps which we've taken. At the Allahabad bench, a total of 10,763 square feet area interior with all the renovation work is being done. Tendering process has also been started. At Mumbai bench, a total of 38,520 square feet area, renovation, interior work, and all those are near complete. In Delhi, the CGO complex, total area of 10,812 square feet area is under renovation, again with interior work, and all are under process. In Delhi, in the MTNL building for NCLAT, the appellate tribunal, total area of 48,720 square feet renovative work is happening. Interior work is almost near completed. That's about the MTNL building in Delhi. For new benches at Amravati near Vijayawada, a total of 9,886 square feet interior and renovation work being undertaken, and planning has already been completed. The interior work will start soon. At Indore, a total area of 9,496 square feet renovation and interior work is being started. Planning has already been done. As we are talking about it, steps taken for capacity building were also questioned. Capacity building for members and employees of the NCLT and the NCLAT. Regular colloquiums are being held for capacity building of members so as to ensure speedier and uniform judicial delivery system. For capacity building of officers and employees, relevant training is also being given from time to time. Ministry has also approved a program of induction level training for newly joining members and in-service refresher training for existing members. The NCLT has been entrusted to conduct the program. Induction colloquium for newly appointed members of the NCLT was held between 13th July and 17th July, if the date is right, in collaboration with the National Law University, New Delhi. As regards resolution professional, Chairperson, sir, the IBBI registers and regulates the Insolvency Bankruptcy Board of India, registers and regulates all the professionals, the CAs, the CSs, the cost accountants, advocates with 10 years of work experience, with at least 10 years. They pass an examination conducted by the IBBI, so they are not just picked up and left without a screening. They have pre and post registration trainings also. So we are giving a lot of attention for these professionals to be absolutely trained and ready. Chairman, sir, Shri Manish Gupta had asked this question about Section 240A, which provides relief for MSME, and on MSME, several members spoke with a lot of concern. I just want to inform the member. This Section 240A provides certain relief to MSMEs. Section 29A clauses C and H don't apply on them. Operational creditors have been beneficiaries. Thousands of applications are withdrawn before admission as the company arrives at a settlement with operational creditors. 6,079 applications for 2.8 lakh crores were realized. I've given the figures. Shri Ravi Prakash Verma spoke about resolution plan under the code and also spoke about realization value and so on. Without naming the case in which this has happened, I want to tell you, the liquidation value of this particular example that I want to read for you was 9 crores. Claims of financial creditors was 900 crores. Realization for creditors was 54 crores. Realization of percentage of claim, 6%. Realization as a percentage of liquidation value, 600%. Underlining the fact that the Insolvency and Bankruptcy Code's resolution plan gives better returns for those creditors. The company was in BIFR, the example that I've given you. I've not named the company, but the company which I've given you an example of was with the BIFR for a decade. Because of IBC, now they were able to come for a solution. Company revived, Mr. Vishwam, the company was revived, and creditors got 600% of liquidation value. Without the IBC, and this is something which I'd like to inform all members, without the IBC, creditors would have got only 1%, which is of the 9 crores of the claim. So IBC actually benefits every one of the creditors, not just the big, Forgetting the small is not on the agenda. In fact, the small benefit, and even more, companies are not shutting, resulting in unemployment. Companies are being resumed, resulting in workers going back to work. Sir, Member TKS Elangovan spoke about dues to government. This is not a new provision, sir. It exists even today as it is under Section 53. The bill only clarifies it. So case laws have also been holding up the fact that government dues to be treated at operational debt level. Sir, the last few, I wouldn't take more of your time. You've been very generous. But I thought it's important for me to respond to all the members who have raised all these important questions. And it matters to the Indian economy that the step being taken by the government through the amendments in the IBC is largely approved by all our members, because that's the message which has to reach the industry, which has to reach the workers, which has to reach public at large, that monies are not being forgotten, the value of the assets are not being forgotten, the workers are not being forgotten through the IBC. It's made for all. It's not made for any one particular section. So, Sri Ragesh had asked several few questions. Corporate establishment and corporate person are not different, sir. I want to inform through you, the member who asked this question. Insolvency of corporate persons has commenced. Insolvency of individuals are yet to commence. Individuals are of three categories: personal guarantors to corporate debtors, partnership and proprietorship firms, and there are other individuals. So individual insolvency will be implemented in a phased manner. We are working on it. We've started the work on it. Sir Sri Vijay Sai Reddy suggested the government should rescue financially viable companies. Government is facilitating the rescue of such companies. The commercial matters are decided, as I said, by the COC and not by the government. The stakeholders who are in the COC decided. Government does not intervene in the process. I think I mentioned quite a few on MSMEs, but there was this question, I'm not sure which of the honorable members had asked, saying what happens if there was an NPA in the bank? What happens if an SME had an account in a bank which is NPA? Will we forget them, and so on? I want to assure here that the provision of the clauses C and H of Section 29A shall not apply to the resolution applicant in the CIRP of the MSMEs. Thus, the promoters of the corporate debtor can make application as resolution applicant even if they have an account with a bank which is an NPA. So, which is, even when they are in NPA stage, they can still ask for resolution. See, Sri Subramanian Reddy, who normally takes a lot of interest in all the bills which come for discussion, goes through a lot of detail, comes up with very valuable suggestions, valuable amendments, also had an observation on the insolvency professionals. He observed that the professionals throw out the management. It doesn't work that way, sir. It's a creditor and control model. We moved away from the debtor and possession model, which I did read out when I did read out the initial remarks. The difference between the way in which the SICA dealt with companies, the SURFACE Act dealt with companies, now the IBC deals with companies. So we have moved away from the debtor in possession model, which did not work at all. So the professional is adequately empowered and enabled. He doesn't throw out managements.
Please. You'll get. You can check up. Actual rule is, once the professional is appointed, he has abnormal powers. He will simply dealing with the board, company board, and complete management he takes, and nobody can touch it. So he can derail the company, and all the creditors, which are the commercial banks, will lose the money. This is very important. Please check up.
Thank you.
Thank you. So the Indian Contracts Act, partly also answering Sri Subbiram Reddy, Indian Contracts Act allows the lender to realize from the borrower or the guarantor also. So a lender should go to the borrower first, then to the guarantor. So I think even as we were discussing in one of the interventions, Sri Kapil Sibal mentioned, take into account the order of priority and value of security interest of a secured creditor. It is the domain of the COC, the Committee of Creditors, to decide. They may decide to take more or less on their own volition. Extent of security interest is a material information. So at this stage, I think I'd broadly touch upon that response. There can always be greater discussion, Mr. Sibal. Through you, the chairman, I'd request for any such suggestion or guidance that he may want to add a bit later. Sir, Sri Ravindra Kumar had said the period of limitation should be there. Section 238A, introduced on 6th June 2018, provides for applicability of the Limitation Act of 1963. So that's taken care of. Before I'll now respond to the 5 points which Jairam Ramesh made as a concluding remark. Successful bidder does not pursue. What happens then? The regulations introduced on 24th January of 2019 requires performance security before approval by adjudicating authority. Criminal prosecution is also possible. So if somebody who is successfully claimed that he can come up with a thing and bids for it and later doesn't show up, criminal prosecution is permissible. IBC has actually overriding effect. You asked whether the IBC will have the overriding over SEBI, for instance. Section 238 provides that the IBC prevails in case of inconsistency between two laws. So counts with actually Indian courts will have to decide in specific cases dependent about the material before them, but largely, yes, IBC. And on individual insolvency, I think, when you spoke about SMEs, promoters, and so on, rules and regulations in respect of personal guarantors to corporate debtor are ready. We would be operationalizing them soon. Two other categories, proprietors and partnership firms, which will also come in the realm that you're talking about, and other individuals will be done in a phased manner, but we are making provision for all of them. There's also this question on which you raised about indemnity for successful resolution applicant. The amendment now clearly making binding on government is one of the ways in which we are providing that. Government will not raise any further claim. Government will not make any further claim after resolution plan is approved. So that's going to be a major sense of assurance for the people who are using the resolution plan. Criminal matters alone are proceeded against individual, not company. There will be no criminal proceedings against successful resolution applicant. There will be no criminal proceeding against successful resolution applicant for fraud by previous promoters. So I hope that is absolutely clear, and this message I would want all the honorable members to recognize and communicate further, that this act, therefore, this code, therefore, gives that comfort for all new bidders, so that they need not be scared, saying, will the taxman come after me for the faults of the earlier promoters? No, once the resolution plan is accepted, the earlier promoter will be dealt with as individuals for their criminality, but not the new bidder who's trying to restore the company. So that is very clear. Information utility is something, again, you've asked something on it. We have only one IU. Creditors are learning to use it. Operational creditors are individuals, mandatory. Everyone to submit information may be difficult at this stage. And the last thing about MSME, which you had raised as beyond your 5 points, Section 240A, Clause C and H of Section 29A, I read this before also, does not apply to resolution applicant for MSME. Government may relax any provision for MSME. You've given a suggestion. We take that on board. We'll see what we can do about it. However, definition of MSMEs in the MSME Act, which is what you referred to, apparently government wanted to redefine MSME to expand if it's expanded scope. We would be able to respond to this a bit later, maybe. However, MSMEs as operational creditors are using the code and benefiting. Some of the figures I read here were benefits which accrued to smaller units. Information utility accepts information from everyone, including the MSMEs. I've mentioned that it can help. Chairman sir, you've been very indulgent, given me all the time to respond to everybody. I hope I've not missed out on any one individual who asked any question, but largely this debate has been very invigorating. I'm very grateful that everyone participated with such in-depth arguments, and I hope once this act is passed,
not allowed. Please.
Once this gets passed, I would only underline the gravity of this. A unanimous passing of such an act gives a message to our economy, and I'm very grateful in the anticipation that we pass this act today.
Thank you.
Very much.